Hello. I was coming on to do my simple, finish reading Ryan Reynolds's motion to dismiss, see what else was on there. And then I saw, as soon as I went to YouTube, I pulled you to the bump, and Lauren having a live, clicked on it. Blake Lively's motion to dismiss. So we'll go over that too. Somehow this day it's already 2 p.m. Over here, and somehow it's like flying by, and I don't know how to feel right now. I don't know how to feel. I was saying something in the chat with Lauren, or on Lauren's videos chat, that is it normal for only the plaintiff or only the defendant to file a motion to dismiss, because we have New York Times, obviously, we have Leslie Sloan, then we have Ryan Reynolds, and now we have Blake Lively. Motion to dismiss, motion to dismiss, motion to dismiss. Wayfair has not filed a motion to dismiss any of the things, any or all of it. And so for me, what that brings to mind is not, oh, well, they want to prove their innocence. Okay, but that's not why I'm asking and where my train of thought was. So my train of thought was, isn't it fishy that the people that started the allegations, that started the war, they're the ones that are like saying, actually, I want to be out of this lawsuit, or can you dismiss that point and that point and that point, please, of their, response to our attacks? I don't know. I'm just saying. I think that's kind of what it feels like to me. Anyways, so I do want to finish Ryan Reynolds's. I'm kind of like stuck now in between because, I mean, they're both crazy making in a entertaining kind of, I don't know if it's entertaining. A few people were like, this is too much for me, this is bringing up some PTSD, CPTSD, oh my gosh. um and I'm like, and I'll say this here too, health comes first, your health comes first, your mental, emotional, physical health comes first. None of this is that important. None of it is that important than your health, your personal well being. Nothing that's going on that you are not a part of, that you do not have to be a part of, is that important. And I understand maybe the conflict of supporting your favorite YouTube person, YouTube creator, content creator, TikToker, whatever they are. I understand that. Um, I I want to say there are other ways you can support them. You don't have to subject yourself to anything that will cause you harm. Period. And I mean, especially because that was a few people on Lauren's chat, on Lauren's video. I believe that she would absolutely say the same thing. She works in that area. And yeah, so the two lawyers said there's probably going to be a lot of filing for whatever they can think of. Yeah, yeah. Well, you know, um, they said, unfortunately, that the paper wars just started. And boy, were they right. Um, Anyways, let's get into finishing. I'm not too far off, I think, from finishing Ryan Reynolds. I'm going to skip, a lot of the quotations of other. If anything that's not sticking up, I'm going to skip it as far as like references, and just stick to the words of their words, and then just jump into Blake Lively's. Hopefully, this won't take too long because there's so much to do today. Oh my gosh. Oh my gosh. All right. But thank you for being here. And if you're watching on replay, thank you for watching it. And I'm going to start the uncomfortable saying, like, please like, subscribe if you haven't, like this video, comment, etc., etc. So yeah, all right. So I think this is where we left off because I have this little highlight. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. And yeah, my thoughts on that were in the last video. Anyways, continuing on, I'm going to go straight into, it is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance of the challenged statements be true. But nothing has been demonstrated for them. Everything has been demonstrated for Baldoni's side, right? Yes, 2026 seems far away with all these filings. Yeah, it seems like we're all going to be triggered at some point to the point of like, I need a mental health break from this case. And I honestly, even with all of these filings, I feel overwhelmed. I'm like, I don't know. I'm a little over this. Not over this, but I need, to pace myself. Um, but also once discovery starts, it might slow down, right? Can they, I mean, like, where I don't know if any of us know this, but I'm just posting or like saying the question, can they file any motions to dismiss? How does the paperwork go after discovery starts, after depositions are in motion? Are the paperwork still continuing, or is it just until that starts? You know? Because I imagine, unfortunately, there might be other things that come up, like, oh, motion to dismiss, motion for attorney's eyes only, motion for this, motion for that. So I don't know. I agree, overwhelming. Yeah. Hi, Maria and Angel. I almost said Rodriguez, but that was the same person. Anyways, okay. So the FAQ includes numerous references to conduct that a reasonable observer could well consider predatory. In particular, the FAQ relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books. So just because they mention this, but like the two lawyers ask two lawyers, I don't remember them mentioning any quotes from the books. I remember like an article mentioning quotes from the books to kind of vilify him, and I remember them, like Blake Lively's amendment, but I don't remember the like Wayfair amendment complaint lawsuit, all that they filed to have that. Maybe just this, mention, we have knowledge of the contents of the books. Relying on statements made on Mr. Baldoni's podcast, okay, the court may consider the full text of documents that are cited in. Okay, so there you go. That answers my question, I guess. Interesting. Incorporated by reference in or integral to the complaint. Those materials, but the TED Talk wasn't. Was it? Wasn't that just like Blake Lively's amended complaint? Again, this is what got me in trouble. I feel like the first time, like, I give them the benefit of the doubt. Like, okay, you're filing this. I trust you're a lawyer and you know the law, you know, as to what to include or what not to include. So we'll see. Those materials with which anyone who knows Mr. Baldoni would be familiar include numerous admissions to behavior that could reasonably be described as predatory. I don't think reasonably is the word that I would use. I feel like, you know, it's a stretch. Someone to be a toxic male, so to speak, as that popular phrase, is not a predator. necessarily. Like there's like a continuum spectrum of things, and it's like saying someone who's selfish is a narcissist, or someone who's selfish is like a sociopath or psychopath. Like it's not the same thing. That's not the same thing. Um so, Jane Randall, Boys Will Be Human, a talk on healthy masculinity with Justin Baldoni on YouTube, saying that I'm sure I have crossed boundaries and lines on in my. This is the podcast that was redacted, that was taken down, right? I'm sure I have crossed boundaries and lines in my teens and 20s, and not even thinking about it simply because of the corn I was watching, I was consuming. I don't even know why I'm trying to like not say these words anymore. I don't even know the laws of YouTube, the rules, what is going to happen if I say if I'm reading, you know, this. I don't know. But again, reasonably, assuming that it goes from 0 to 100, that's not a reasonable assumption that just because he was watching corn or consuming corn, I think is a better analogy, doesn't mean that, you know, doesn't mean they're like, he was like chasing and stalking and like, you know, predatory to me is like with like malice, intent of malice. I think it's very different, but that's like my interpretation of the word. I don't know. Let's see what Google has actually. Define predator. Because, when you think of predators in their natural habitat, like animals, predators and victims, predators are like they stalk the victim, they want to catch the victim and like, well, eat the victim in nature. Relating to or denoting an animal or animals preying naturally on others. Well, didn't we learn in school not to use the same word in the definition? Seeking to exploit or oppress others. Okay. So to prey, catch and kill for food, take advantage of or exploit, cause constant distress. Okay. I don't know. To me, predator is a lot more than just like causing ill to others. I mean, that's bad, but if you don't have intent, that's like different. Does that make sense? Like to me, that's what like a predator is. It's like intent to do bad, which I guess they would say, well, exactly. Um, let's see the definition of this. Well, it doesn't have a definition. Okay. Hunting or stalking behavior where the person is seen as actively seeking out and targeting vulnerable individuals. Vulnerable. I'm sorry, I'm so over Blake. I am so over her. My friend is watching Gossip Girl. I'm like, I cannot stand to see her. I was recording something for Lauren for her video coming up, and I was saying at the end, I didn't even end up recording that part, but I don't wish any ill on her, Ryan, anyone involved on any side. Um, I don't want them, unalive. I don't want them anything that people I've seen in comments and chats and things say. Same with Colleen Hoover. I hope she's well. I hope she gets help because she needs help one way or another because her behavior, even if she's just faking it, which I don't believe, but even if that's true, I just, she needs help. She needs help. She's in distress. That's not okay. And these people also, they need help. However, I also believe in consequences. I can hold both of those things. Consequences doesn't mean that I wish them ill. I just don't, I don't know. I don't subscribe to that. Um, but I also don't believe them. I don't think what they're doing is okay in any form. Um, anyways, this is just like, sorry. My brain just kind of stopped. This is stuff. Okay, whatever. So on the Man Enough podcast, Jamie Camille, Changing the Narrative on YouTube. I grew up and I had an addiction to corn. I was introduced to corn 10 years. I don't know. Anyways, at 10 years old, formed these neural pathways in my brain, and it caused me to see the world very differently. That's a lot of people in this world, or in the US at least. A Life of Greatness. Justin Baldoni, The Power of Being Enough. Apple Podcasts. Don't believe that was cited. This is the thing. I don't believe a lot of these were cited. Correct me if I'm wrong. And for me, it was really tricky because I believe that there's a link between that culture and that culture. I'm not calling out the corn industry. I'm calling out my relation to it, but I do believe that especially um, the corn that young boys are watching is very violent. And because we never, again with the like highlight, because we never, no one ever sits down and teaches us about consent, we learn it through corn. That's like kind of really messed up. That's a whole other conversation. This is so just insane to me. And reading this also is just like, are we not grown adults? I can't believe I'm reading this. I can't believe people are like discussing this to attack men and women on Wayfair side. There's both. It's just insane to me. That thing, like I mean, this is the dirtiness of legal process. That's why people say, be careful of divorce, sign that prenup, whatever. You don't want a messy divorce because even like people that love each other or used to love each other, at least, like it'll get dirty and ugly. And this is kind of what that kind of comes across. Like they will find any tiny little crevice, any tiny little crumb, and change it up to fit their, you know, point. Um, but I haven't seen anything of him saying anything. You, right, as a black man or you as a woman have had to put up with a lot of stuff from people that look like me and or from me your entire life. And again, it could be laundry or it could be microaggressions for racism or sexism, whatever it is. I've done all of them. Um, microaggressions. He's admitting to doing microaggressions, and that makes him a predator. Again, just looking at this one, because this is, what he said in that one. I wanted as a man to claim her publicly. Don't think that was schmextual. As on some level, I knew it would make me feel more like a man. I believe this, if I would read this one way or another, like that to me sounds like he wanted to like show her off in public that this is her, that this is his woman. I don't know how many times. I don't know what world these people live in, but I don't remember ever claiming a woman in public is like having schmecks with her in public. I don't think this is the same thing. Why did they even include this? Just to like, what? Oh gosh, the desperateness. The desperateness. We talk about who we're hooking up with, right? And oftentimes, as Tony Porter says, and from a call to men, he talks about the language that we use, right? It's actually violent. Do you smash that? I just cannot believe that he's like brought in, like pulled into this craziness. Like everything that he's saying is so elevated, so like advancing the Me Too movement and advancing the, rise above violence. What the heck? I needed this book as the 18-year-old freshman in college who felt the need to prove his masculinity by hooking up with as many girls as he could without any regard for their feelings or attachments in the process. And as 31-year-old who had not treated women with the respect he knows they deserved both socially and romantically. Past tense. Past tense. He's 40 something, right? Hi P. Um he's 40 something now. This was like, wait, this was in 2021 to begin with, what he was reflecting on. This is so, man. This is more what I'm worried about now because I don't want people to quiet their reflections, what they've learned, their life lessons, So the conversation can be advanced just because someone can use it and spin it and, manipulate it against them. I agree. I just want Justin to have some of his life back. Yeah, that's the only way. Justice. They're going to throw anything they can get away with. Yeah. Um. Yeah. That's sorry. That was brain just kind of froze. That's what I was saying. It's like I don't want them because my brain froze back then too. I don't wish them ill. I just want um, the proper, just and fair consequences. That's all. I don't, and then that includes having things boycotted that they're in. I think that's fair, especially at this point. I think that it was like it probably wasn't huge of a boycott movement before they have increasingly come even more aggressively at this whole thing from just trying to manipulate us. I remember feeling the pulse of the internet rise with that first and second reaction to that video, when they were like trying to say, yeah, see exactly what we're saying, believe us, and trying to rally up women, as if we're anything like her. And was it Dave Neal that was saying this, or someone was saying Lauren? I don't know who was saying this, but that's why it's so important to differentiate Blake Lively from women. This has nothing to do with women. I mean, sorry, I take that back. Obviously, she's a woman, but this has nothing to do with a conversation around women and claiming SH and whatever. She created this. Whatever we say against her is for her. Just like with Justin, it's not about all men, it's about him. And it is like, of course, the conversation with the gender and the complexity of gender and um, accusations and blame and victimizing and assault and all that stuff. That all is underlying, but really, this is her. And really, not even just her, it's her and her husband. Like, it's more about an abuse of power over and over and over and over again, taking over the movie. Because, yeah, and um, in her complaint, she was talking about like she basically volunteered her services. I'm like, oh, how kind of her. I cannot wait to get to that one. Sorry, I'm like talking too much on the side, but it's one thing to be like joining a collaborative process and another thing to take over. Taking over is not collaboration. You editing and having your own editing, edit version, sorry, that is not collaboration. That is not collaboration. Even if you're a producer, that is not a collaboration. That is taking over. That is doing your own thing. Someone was saying, I think in the chat, firing ADs, firing people, cutting scores that for the movie that were already created. That is not collaboration. Altering, saying, hey, let's keep this one, but let's like, I don't really like how the violin sounds in this one or whatever. Or like this part should be more this emotion than that emotion. That's collaboration. Saying scratch all of that, let me start with my people, let me start over, let me do what I want, that is not collaboration. Side note, I'm getting ahead of myself. Anyways, hi Arnaldo. Okay. While it is unclear that predator means to an average what predator means to an average listener, it is quite clear that there is no discernible distinction between the gist, I don't know, I just find the word just is a joke, of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography. Said the word, whatever, as well as openly describing his distorted conception of consent in sexual relationships. Now, as I'm reading this, I'll say my gut, my thinking leads me to think that no judge would say, oh, yeah, okay, yeah, we'll dismiss because he's, you know, said the things that you've quoted him to say. Nothing that he said was A, in present tense, B, even what is really being alleged that he said. I don't believe that they were like confessions of what was it? Um, confessions to mistreating women, addiction, all this stuff. Like, yeah, I mean, I guess, yeah, but I don't know. That's kind of confusing too, because his story from college was the opposite, but whatever. Um, I just don't feel like this is a purpose to dismiss. This is not a good standing to dismiss anything that is going on. We're not talking about, in the end, this case is not about his character. This case is about, did he or did he not create a smear campaign in retaliation for her speaking up about um, sexual harassment? That's literally the summary, the thesis, the blurb, I forget what he called it in movies. Like that is what this is all about. So to motion to dismiss because of someone's character, that doesn't make sense to me. But I'm not a lawyer, I'm not a judge, I'm not in the legal system, so I don't know. But to me, that those are apples and oranges. Um, yeah. Sorry, I just wanted to say that. I'm gonna try to stick to this, just to get through this, because the Blake one is even crazier, and we really did get through most of this one, the ideas. Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegations that he is a predator, but the law offers no principled basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. What? Finding substantial truth where an article called plaintiff an adulterer because an average reader would understand that term to include the admitted truth that he was a man who unabashedly committed adultery for 13 of the last 17 years and whose adulterous behavior. But those were proven facts, I imagine, or provable. Like, you have not proven that he did what you are saying he did. But I do agree that it is his burden to prove, he's innocent. It is. That's what they're doing. It is his burden to prove the factual falsity of the allegations. But it's also their burden to prove the factual allegations. What would you call that? The allegations being true. I try so hard to. Oh my gosh, my brain. This judge will probably speed up discovery so they stop filing to dismiss. Yeah, yeah. He's probably like, I do not want to deal with this. But again, apparently this is normal. So I have definitely a lot more care and compassion for judges. They put up with a lot. I mean, they're really parents with kids that are like, no, he did it. No, he did it. No, he did it. No, he did it. And then, yeah, I commend judges' patience with people. All right. It would be perverse to permit Mr. Baldoni to build an entire brand complete with a podcast, TED Talk, and books. Yes, exactly. Off of his confessions of repeatedly mistreating women, not off of his confessions, but off of your allegations. Of if your allegations are true, it would be perverse. Off of him saying, "Hey, I learned my lesson. I did all of these things that I say that I did, in the past, or I've watched, friends and others that have done that or worse, and I'm here as someone who's wore through it and wants that to stop." I don't know. Sometimes when you put it in like simple terms, it becomes less, not even less confusing, more harder to like go against, I guess. Only to turn around and sue Mr. Reynolds for $400 million for simply pointing out in private that Mr. Baldoni has bragged about in public. That is not what we have seen Reynolds do, though. In light of Mr. Baldoni's own public admissions, but I will say that could go towards like the nice pool thing. But again, that's not, because the nice pool was assumptions. It was assuming of intention that wasn't like, if he would have just said what Mr. Baldoni would have said or presented it and let us kind of make our decision instead of interpreting it and putting his own assumptions into it and making us have a distorted opinion. That is, I feel like those are two different things. In light of Mr. Baldoni's own public admissions, of which the court can take judicial notice, um, notice of excerpts of books and articles written by plaintiff prior to alleged defamation attached to defendant's declaration due to their references to these things. The substantial truth doctrine requires dismissal of Mr. Baldoni's defamation claims as to Mr. Reynolds. I like what the two lawyers said, though, in this case, because the context is, yes, Mr. Reynolds may or may not have, but if he did, it's because he believed it, said things to someone that directly had an um, power over Mr. Baldoni's career, professional life, work, income as a result, things like that. And not just like reputation, but then also that layer too, because of the context, this being Hollywood. So, and then, but that is more that is, I think, more on the Blake side of things. It's hard to, know exactly who, right now at least, came up with the ideas that were fed to the press on the Lively side, etc. So I don't know on that side. But yeah, the fact fails to plead special damages. Dismissal of the defamation claim is warranted because the fact does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient particularity to identify actual losses. Defamation claimant must allege either special damages or defamation per se. Under California law, a plaintiff may only prevail if the publication is libelous on its face or if special damages have been proven. But that's like publication, that makes me think it's referring to publications, right? Or is it just the publication of like including words that are being spoken by people, like making things public? But to me, publication usually is newspaper, a magazine, things like that, which Mr. Reynolds is not. This particularity requirement is strictly applied, as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity, far from fully and accurately identifying any harm that flowed directly from the injury to reputation caused by the predator. I don't think this is like even, this I feel like might be one of the easiest ones to prove, in my opinion. Media, yeah. Um, yeah, I want to say this one might be one of the easiest ones. I don't know. Maybe I'm completely wrong. But I mean, there is a direct cause from him talking to, again, someone that's in the agency. If it's proven, I mean, we have Ari Emanuel's, vocal recording, whatever, that magically disappeared. I can bet that they might subpoena the original recording that was supposedly not recorded, because lawfully they will have to provide it, even though they don't have to provide it to us, the public. I would go there as Brian Friedman. I'm sure he has already, but I would go directly to the podcast saying, hey, can you have to provide this? Or, like, go to the courts, like, hey, we need a subpoena for this podcast. We need that recording. And kind of like they did with Disney, do not destroy any evidence, basically. Maybe it's too late. Maybe they already have destroyed it. I find that really hard to believe. I don't remember of anything where I've destroyed any of my files. Just, file them more privately, or, like, harder to get to or whatever. Yeah. But some people, like, shred things. So I don't know. It could be possible. But worth a try. Worth a try. Because that alone proves a little of this, I feel. Um, okay. Because he said, like, I believe them. Uh, didn't he say, like, they told me this and I'm a ride or die or something like that? Maybe not. Maybe it was just the gist of it, as Mr. Reynolds would say. Finding failure to sufficiently plead special damages where complaint has neither pled its damages with particularity nor plausibly alleged a causal connection between the alleged statements and a lost sale. With fact prayer for relief, compensatory damages, including, okay, whatever, yeah. The court should strictly apply the particularity requirement and dismiss the defamation claim for failure to allege special damages with the requisite degree of specificity. Okay, well, they'll come back to that one, I'm sure. They'll be like, well, you want specificity? Here you go. Although they already had specificity. The fact fails to plead facts demonstrating actual malice. As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Reynolds uttered the predator statements with actual malice. In other words, that Mr. Reynolds in fact entertained serious doubts as to the truth of his publication. I don't think malice is because you don't believe it. Malice, like having an intent for malice, and I don't know if this maybe in the legal world is different, but having an intent to, like, cause harm is regardless if you believe or don't believe it being true. Like, because, okay, let's say supposedly, theoretically, Mr. Baldoni is what Mr. Reynolds says he is. And Mr. Reynolds knows that and believes that at the same time. And Mr. Reynolds says, the predator statements to, I cannot believe I said predator, says it to Ari Emanuel, the literal president of the talent agency that also represents Mr. Baldoni and Mr. Reynolds. And this is all, like, supposed theory, let's hypothetical, right? Let's say all of this is kind of what's happened, and supposedly. And I will say that, like, you don't have to say that to someone. I don't know. Like, I don't know. I feel like you can have complaints, you can go down the legal system, you can, have complaints in the workforce, you can go to different things like that. But going straight to someone who is not really related to having a verdict of some sort, like a I don't know what I'm trying to say. To me, that's like having an intent of malice. That is Ryan Reynolds wanting this guy to suffer. It's not going through proper channels of justice. That's not justice. It's like, I just want revenge. That's what I'm trying to say. If, as a hypothesis. In order to prevail on a defamation claim against a public figure, a plaintiff must demonstrate by clear and convincing evidence that the defendant acted with actual malice. The plaintiff is a public figure, and then he must prove that the defendant acted with actual malice. Blah, blah. The facts conclusory assertion that the lively parties, defined to include Mr. Reynolds, knew the statements were false or had serious doubts about the truth of the statements is a threadbare recitation of the legal element that is insufficient to sustain the law's heavy burden on defamation plaintiffs. Okay, I mean that's kind of fair. Um, but I feel like it still needs to be proven one way or another. It needs to be proven one way or another. Yeah. Holding that, oh, this is more things. Nor do claims of animus, like Mr. Reynolds' deep disdain for and wrath directed at Mr. Baldoni, sufficiently plead actual malice. Actual malice has nothing to do with bad motive or ill will. Okay, and may not be inferred alone from evidence of personal spite, ill will, or intention to injure on the part of the writer, which is why I was saying, like, I don't know, maybe in legal terms, malice means something else, which is really crazy to think of. Then what does it mean? Does Google know? Protect democracy. Just is the legal standard established by the Supreme Court for libel cases to determine when public officials or public figures may recover damages in lawsuits against the news media. Okay. Cannot libel cases without proof of actual malice. But what is freaking actual malice? Why is it so hard to give just a plain definition? I don't know. Define as with knowledge that it was false or with reckless disregard of whether it was false or not. Well, that's important. That's kind of important, right? Because even if they believe, like, we don't care to know if it's true or not, we're just saying this because we got hurt by this. That's also something. All right, moving on. But I don't know. That could be, I guess, a burdensome thing to prove. I don't know. But that's like, I feel like it's too early. They need to have so much discovery, right? And isn't this like what discovery is for? To prove all of these like allegations on both sides? I heard Baldoni broke a rule. I guess this happens in this industry. What rule? What do you mean broke a rule? It would be consistent with the fact to find that Mr. Reynolds uttered the predator statements with actual malice. Indeed, there is not a single plausible factual allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the fact alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's woke feminist facade in Deadpool and Wolverine. That's an interesting way to spin that one in their favor. Not to mention Mr. Baldoni's own public admission about his past conduct. The deep disdain that the fact alleges Mr. Reynolds feels towards Mr. Baldoni concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of actual malice. Okay, so they have to double down on the actual proof of that. They wanted him to take it and move on to directing his next movie. That's why Ari, Reynolds, etc. are upset. Explains why he was ghosted. That was like the other sorry. should have put that one up at first. That brings me to something that I almost forgot to mention. Um, I think this is also, I mean, I know I hear this is pretty normal to like, you know, talk about or motion to dismiss this and that, whatever. Paperwork, as the lawyer said, etc. However, considering the public figures that are roped into this, that did not seek to be roped into this, I wonder if this is also a huge pressure on them from those people, on Blake Lively and Ryan Reynolds, because you have Taylor Swift who's like, what are you doing? What are you guys doing? Why are you bringing, like, I will be brought into this. Why is this happening? Um, okay. Um, you have Ari Emanuel, you know, his his podcast suddenly disappearing magically. Um, yeah, he's being brought into this. I'm sure other people will be brought into this. She wanted to bring other women on set into this, and that might not be as powerful, but maybe they're close, like family, like her sister, or even Jenny Slate, being a friend again and backstabbing her, or maybe she believed maybe that happened also. But I don't know. This is a theory that popped into my head on Lawrence Live earlier. Like, I wonder if like all this pressure from these hugely powerful people is like on their shoulders, and that's why they're like, we need to like end this. We cannot go to court because cannot even go to deposition because or discovery because these people's dirty laundry will be exposed, or even just like their name being dragged in to it is not a good thing, and they will drop us, as friends. As I don't know, Ari Emanuel said he's ride or die, but I don't know. I feel like when the bottom line is concerned, I don't see him as someone who sticks out, loses all his money for two people. I'm sorry, but I don't see that. And things like that. So, yeah, because they're playing with such dangerous fire when it comes to that. I think now it's even more, to me, more noticeable than it was before, that they were just so selfish. They're doubling down, trying to make it look like they were doing a noble thing, but they were being so selfish. They're coming from such a selfish place because they didn't do things earlier. I'm sorry to say that. I know people say, well, that's not an argument. I believe it's an argument. I believe it's a fair argument and a fair expectation for them to have had actually, gone to any HR, all HRs, the Wayfair HR, Sony, Columbia, whoever, all of them, their talent agency, whoever, saying, hey, this is what's happening to me. This is what happened to me. And just also like not waiting for 32 points of it, going straight after like one or two or three or even five. She didn't need to let all of that build up. If that's even like an argument, because a lot of that stuff I feel like is um a misinterpretation of events and not actual malice or things. So, yeah, I heard it somewhere. I don't remember. It does make sense. This business is cutthroat, scary. Even celebrities act like the mafia. Yeah, yeah, that's what I was saying. But you guys also corrected me that that when did I say about, I don't know. You corrected me something about the correlation. I think I gave the mafia too nice of a spin or something. I don't know. Crazy if true. Yeah. Gosh. Anyways, I just yeah. This is it's yeah. I think last chat you guys were saying cry wolf behavior. Oh, this is so crazy and entertaining at the same time. Won't lie that it's not entertaining. Even if it's like overwhelming, but sometimes overwhelming is like just because it's like, what is going on? I can't believe this is happening. Um, the predator statements refer solely to Mr. Baldoni and any of the six other Wayfarer parties, and not any of the other six. Not Jamie, because I remember, yeah, yeah, because he was trying to say, well, Justin forced Jamie to show Blake the video of Jamie's wife giving birth. So okay. Yeah, that was a new spin because I thought they were alleging that it was just Jamie wanting to do that. I don't know. That was like in the initial Blake Lively complaint, as far as I remember. But yeah, now it's just Justin. So let the other people go, right? Dismiss the allegations against all the other people, aka I don't know, the whole thing being about the smear campaign, let that go because that's mainly like all the other people. um, where was I? It requires dismissal. Oh, sorry. To the extent that the FAC intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni, it requires dismissal because the predator statements are not of and concerning any of them. Okay, that's fair. A false disparaging statement. Yeah, the I think the defamation claim, like, I would say there's like multiple ones. This is why like it's so complicated that they like you know merged all of them in one lawsuit. But yeah, a false disparaging statement about IBM, for example, would not, we think, ordinarily be a defamatory statement of and concerning all of IBM suppliers, employees, and dealers, however much they may be injured as well. Okay. Dismissal required when plaintiff fails to meet burden showing statements. To meet burden showing statements was of and concerning him, and burden is not a light one. Sorry, sometimes when I read those, it's like I'm reading the words but not being prepared of what the words actually will say, so they sound like a robot. Because, I guess we're all bots. I think that ship has sailed, though. I think they know we're not because, we got attacks. More court filings? No. Okay. The Wayfarer complaint fails to state a claim of false light. The fact fails to state a claim of false light as a matter of law under either New York or California law. There is no tort of false light invasion of privacy under New York law, and the court need not engage in any further analysis in order to dismiss such a claim. That's, that sounds so pompous. Like, you don't need to, further investigate this. Just trust us. I don't, I can understand them saying that, but like the way that it sounds. While California law recognizes claims of false light, dismissal also is required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. Brooks versus Physicians Clinical Lab. Wow, I'm so inconsistent. Sometimes I just start reading things that I didn't read before. While the fact's false light claim suffers from the same fatal lack of specificity described above, which alone requires dismissal, it also fails because it appears to rely entirely on the alleged public disclosure of information on which the defamation claim is based. Sorry, yawn break. I think just reading this is making me sleepy. Actually, I was talking to a friend over the weekend. I was telling her we're in a bookstore. So they're talking about reading books and how like we just pass out instantly. And yeah, like I have a picture when I was little, falling completely asleep while reading my science textbook, and I love science. But yeah, it's just the fact of reading, the motion of reading, the whatever of reading. Oh, it also fails to. I think I read that right. Finally, even if all of that were not this positive, the false light claim fails as a matter of law for all the same reasons that defamation claim cannot survive dismissal. Isn't that like the opposite? Cannot survive dismissal. No, I think my brain's just going crazy. Sufficiently pleading false light requires pleading and proof of special damages. Where a false light claim is in substance equivalent to libel claim, should meet the same requirements of the libel claim on all aspects of the case, including proof of malice, blah, 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 blah. Okay. There is a conflict between New York and California law as to false light because, as discussed herein, the former does not recognize such a cause of action. The court need not engage in a choice of law analysis, however, because the outcome under either jurisdiction's law is the same dismissal of the claim. Okay. Or so you say, so you claim, so you're telling us. Whether applying New York or California law, the court should dismiss the facts false light claim. The Wayfarer complaint fails to state a claim for civil extortion. Now that you mentioned books, I tried your Amazon link and it was not found. Oh, boo. Okay. For his book, um, that's good to know. That's interesting. I'll look at it. Um, yeah. Hmm. I know that I did like a new website. I wonder if that changed it, but was it like the website link or the link directly to the book that's on my, I don't even remember what I linked. But yeah, I'll look at that. That's so interesting. The civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize extortion as a tort or as any private right of action. This is so confusing, isn't it? With all the. Sorry, I'm like thinking two things at the same time. With all the um, different court laws, like, well, in this court, you can, you know, claim extortion. In this other court you can't. Well, I don't know that's what they're saying, but kind of that kind of stuff. Oh my gosh, this whole Mahmoud Khalil thing is just, I was saying the other day, it sounds so too close to I'm Still Here, the movie I'm Still Here. Ainda estou aqui. Hakim. um yeah, it's sorry, I logged on to my Instagram so to see like the link of stuff. Um okay. Hmm. It's interesting. Interesting. So I'll put it in the chat now. Let me know if that works. Um yeah, like I said, I created, I don't even know, shoot, I don't even know if I have the book yet on here. I may not have the book yet on here because I think it was like an other situation. But let me know if any of those work. Yeah. Just let me know if you can see the site at least. All right. I may have like an outdated, I think I have an outdated link in my descriptions. I think that's possibly what's going on. But yeah, what was I talking about? What was I talking about? Oh, yeah. Sorry, I completely I did three different things. Yes, that's the one. Sorry, I did like a completely just like this a complete ADHD situation over here. But yeah, so it kind of is like crazy to me that in one country, different states have like what is it called here? Uh, torts. I don't know. But again, maybe I'm misunderstanding what a tort is, and I would look it up, but I just want to get through this. Sorry. We're so close. Okay. Similarly, although California federal courts have divided over have divided over whether California recognizes a civil cause of action for extortion. The most that California state courts have recognized under the heading of civil extortion is a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution, where the threat of prosecution is made with the knowledge of the falsity of the claim. Sorry, ADHD thought number, I don't know what number. But as I was reading this, I'm like, I'm messing up. I'm still yawning, but I feel a little bit more awake than when I do this at night, which it makes sense. But yeah, sorry, just stream of consciousness is my middle name. Because that cause of action is a form of fraud, it must be pleaded with particularity under Rule 9b. The fact is devoid of any allegations, much less particularized allegations that Mr. Reynolds obtained any money or property from any of the Wayfair defendants or made any wrongful threat of prosecution, much less with knowledge of the falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The fact fails to allege that Mr. Reynolds either obtained any property or consideration from any Wayfair defendant, because of course he did not, or did so through a wrongful use of force or fear. Well, this one's I don't know about force, but fear, I feel like when you yell at someone, that's pretty fearful. I'm not sure what else you would assume someone who you're yelling to feels other than fear, intimidation. But I'm not sure if that's like related, that incident is related to extortion. So, but that's, I don't know, that's a good one to that just stood out. Like, yeah, fear, not much talked about. Not much talked about. Wow. Okay. Wait, sorry for what? No sorry. I don't like when I say sorry. No one should be sorry. Blake should be sorry. Ryan should be sorry. Um, but yeah, I don't. I always feel like, what did I do? When you say sorry. The intentional interference claims must be dismissed. The tortious interference claims. Okay, I do need to look up this tort situation. A wrongful act or an infringement of a right other than under contract leading to civil legal liability. Okay. So extortion is not in New York? Is that because of Wall Street? Because they're extorting all the time? So they're like, well, we can't have this in, this district court. That's every day for us. That's a joke. That's an assumption. That's an opinion. That's a joke. I don't know. I don't know for sure any of that. I feel like I need to cover my bases now, because you never know what you say. It's like, well, look what she said. It's like, okay, that was sarcastic, but cool. I believe it, but that doesn't make it true. Huge distinction. Doesn't make it untrue either. As an initial matter, each of the tortious interference claims must also be dismissed as duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims, where those causes of action seek damages only for injury or reputation, or where the entire injury complained of by plaintiff flows from the effect on his reputation. And this is not that. Whether Mr. Reynolds' alleged statements to WME are actionable in light of their claimed effect on Mr. Baldoni's reputation must fall. As well, under the pleading requirements for defamation. Nonetheless, each claim fails on its own terms as well. I feel like that said a bunch of nothing. The fact fails to state a claim for intentional interference with contract. Gosh, what page are we on? I'm so over this. Page 28 of 38, 10 more pages. Gosh, I don't want to do 10 more pages. As an initial matter, each of the tortious interference claim must also be dismissed as duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims, where those causes of action seek damages only for injury. Wait, sorry, I just wrote that. I'm so sorry. I just read that. Whether under New York or California law, I think I just read that. Whatever. Intentional interference with contractual relations requires that the plaintiff allege the existence of a valid contract between the plaintiff and a third party. Well, it was defendant because right, he's under WME, talent agency. Um, oh my gosh. Wow, sorry. I just like with the time. Defendant's knowledge of said contract, defendant's intentional procurement of the third party's breach of the contract without justification, actual breach of the contract, and damages resulting from the breach. And to all of that, I would argue, well, this is what this trial is for, and the discovery is for, and the depositions are for, because we truly believe this. We have our own, pre-proof, if you will, and yeah, we want to seek the evidence for what we, fully believe is true. To survive, and it sounds very true. It sounds so true. All of those sound exactly like what happened. To survive a motion to dismiss, a plaintiff must specifically plead the existence of a valid contract. And I don't understand this whole language tone of to survive a motion to dismiss. Like, why are you condescending? Is that how lawyers talk? Because I would feel like that's what a judge would say, or that's what, like, a law something. I don't know. Not like an opponent, you know? Does that make sense? Oh, bye, Maria. Um, Yeah. See you next time. Where was I? Where was I? To survive a motion to dismiss. Furthermore, because a claim from tortious interference requires a showing of breach, contracts that are terminable at will generally cannot provide the basis of such a claim. Okay. Dismissing claim or allegations left open possibility that contract was terminable. And plaintiff must also plead specific allegations of the defendant's knowledge of the contract, including some knowledge of the terms and conditions. I don't even understand this whole contract situation. The fact fails each of these requirements. The sole contract alleged in the complaint is a contract between the Wayfarer parties and William Morris Endeavor WME, but the fact does not allege any details about the contract, including which parties it allegedly bound. Surely not all 7 Wayfarer parties were parties to it. Okay. What the contract's terms were or what provisions were allegedly breached. Strikingly, throughout the entire fact, there is not a single allegation that WME breached its contract with any Wayfarer party, much less a description or quotation of a contractual term allegedly breached. Dismissing tortious interference claim where no facts present in the complaint to support an interference that the plaintiff's termination constituted a breach of any contract. Okay. Instead, the Wayfarer parties allege solely that, upon information and belief, Ms. Lively and Mr. Reynolds induced WME to cease performing under its contract. But the cessation of performance is not the same thing as a breach of contract. Okay. And the Wayfarer parties who have alleged the existence of this contract and are presumably in possession of its full terms have utterly failed after multiple tries, hundreds of pages, more media interviews that can be counted. I don't think there were that many interviews. What, they were like 5 interviews or something? And a publicly launched website of the legal filings. Not even all of these. to identify any actual contractual provision that they claim WME breached when it allegedly ceased performance. I will say that this would be really messed up if that's true. Like, anyone can claim anything, make your employer get rid of you. Because, like, Ohio is, or like, is it by county? I don't know. I know that all the jobs that I've worked were at will employment. It's like a law here, whether it's a state law or like county law, I can't remember. But if someone would come in and say, hey, Arena did this or she's this, they didn't even say, oh, Arena, Mr. Baldoni did this. Like, he's this, you should let him go, or else we walk. I don't know what the phrasing was. Obviously, like, in my case, it wouldn't be necessarily a coworker, but maybe. Sorry. But if anyone can walk into your employer, make claims about your character or something that you did or who you are, whatever, and the employer lets you go, I don't think that's just cause. Because I feel like at will employment is still, you still need to provide some sort of just cause. Um, I don't know, but I might be wrong. But that would be so messed up if that's true. We need to fix that in the legal system because anyone can say anything and then you're just done. Whether or not you did that thing or you are that thing or whatever. That's so messed up. So, I mean, I don't know. And I don't think that Mr. Reynolds would like that either if the shoe was on the other foot, which I don't know, at this rate, it probably will be. I mean, he'll be under a lot. If he continues on with Deadpool and stuff, he will be under microscope, I feel like, from a lot of people in the industry, which, if they work with him and they do something or he does something and they feel threatened, like, oh, let me go to HR, let me do my complaint, not even going as far as suing him, because that, I feel like, should be a last resort sort of thing. um I mean, it depends on what the thing is, but yeah. uh okay, moving on, sorry. The fact fails to state a claim for intentional interference with prospective economic advantage. In the absence of an allegation that a specific contract was actually breached, the fact must satisfy the more stringent requirements for a claim of intentional interference with prospective economic advantage. It does not. To state such a claim, a plaintiff must allege it had a business relationship with a third party. The defendant knew. Okay, this is all repeating. I guess like it makes sense, because this is not. This is like, okay. I mean, it's just like, uh, yes, they can't fire you unless they have proof about your work performance being less than required. Yeah. Um. Yeah, that's what I thought. Like, there's like, you can't just like, it is at will, but like they still have to have some just cause. Once again, the sole economic relationship alleged that fact is between the Wayfarer parties and WME without specification as to which of the Wayfarer parties had such a relationship. All right. The fact does not even attempt to allege that Mr. Reynolds acted solely out of malice, as is required to survive a motion to dismiss. But the fact itself asserts that Miss Lively and Mr. Reynolds were motivated, at least in part, by a desire to seize control over a movie production. I don't know if, I mean, okay. I don't think it asserted. I feel like it was like, hey, mm, look at this. Look at what happened here. I don't know. Is there a relationship between these two things? Maybe. That was my take on it. uh, taking that allegation as true, as the court must at this stage, whether or not it is true. Such a motive akin to normal economic self-interest is inconsistent with the sole purpose of inflicting intentional harm and insufficient to state a claim. Is it? Wait a second. No, it's not. An insufficient insufficient to state a claim for tortious interference with prospective economic advantage. I'm sorry, but when you're like normal economic self interest, when you're, you know, trying to take over something, I don't think that you're like not walking over people. Um, what? Okay. But celebrities are a different world. Yeah. Yeah. Well, they are, but that's why they go to court versus us folks that we couldn't. Nor does the fact, I don't think like the laws are different necessarily, but yeah, things can go differently. Nor does the fact allege that Mr. Reynolds employed any wrongful means. Um, to satisfy that element as a general rule, the defendant's conduct must amount to a crime or an independent tort. But there is nothing in the fact that amounts to an allegation of wrongful means. At most, the fact alleges that Mr. Reynolds approached an executive at WME and suggested the agency was working with a sexual predator, and at a later date demanded the agent drop Baldoni. Oh yeah, forgot about that part. So that's not interference with a contract. But sharp language, such as insulting a defendant by calling them a thief, a scumbag, is not wrongful or culpable conduct sufficient to qualify as wrongful means. And pleading, are we going to? I wonder if they're going to address the drop point. In pleading, the presence of false statements alone is not enough to support a claim for tortious interference. The fact lacks a single allegation suggesting, let alone establishing, if taken as true, that Mr. Reynolds' alleged demand was anything other than an expression of sincerely held beliefs, which are neither criminal nor tortious under the First Amendment. Tell that to Mahmoud Khalil and other people, but that's deviating from the point. The fact fails to state a claim for negligent interference. The negligent interference claim must be dismissed because there is no claim for negligence. So they didn't um, address the drop. Because okay, like you're saying, oh, I think this guy's bad news or whatever. Again, context I feel should definitely matter, but besides that, they allege that he said to drop them, that he demanded to drop them. And furthermore, I believe I don't know, it's so long ago Justin's amended complaint, but wasn't there like a screenshot, maybe it was just in paragraph that Sony, I think, like an executive at Sony or someone at Sony told them, hey, like this is what they do. Just, play dead, roll over, and move on to the next project. Because you won't win, because this is what they always do. Something like that. That was the gist of it. So, you know, yes. Maria. The negligent interference claim must be dismissed because there is no claim for negligent interference with prospective economic advantage under New York law and even under California law. It's okay. Only where the defendant owes the plaintiff a duty of care. Okay. The fact fails to allege proximate cause. Yes, Sony. Yeah. Each of the tortious interference claims must also fail because the fact does not allege that Mr. Reynolds' alleged conduct proximately caused WME to cease performance. But he just said that they allege that he said to drop him to cease performance. The fact is silent as to how Mr. Reynolds, someone who does not own or control WME, could plausibly cause WME to cease performing its contract with Baldoni. I don't know, because you are bringing in a lot more money than this guy, and so you're threatening to walk and go to some other agency. I don't know. I Doesn't that happen? That happens. Um, Sorry, my voice got really annoying there. I think allergies has have come in, so I'm like more nasally than usual to appease her, so they can put the movie out. Yeah. Um, but I don't remember if it was like a screenshot. I think I'm 80% sure it was a screenshot, because I think at first it was just kind of alleged, and then in the amended complaint in that timeline, I think they included a screenshot. I think. Maybe not. I don't know. Um, but again, all of this stuff, as a non-lawyer, non-law, non-judge person, I would assume you make your claims and then you go to discovery to get the evidence. Excuse me, evidence to, and what's the other one? Gosh, not deportation. You know what I mean. Their interrogations of, of people, to get the um, evidence for what you claim, and then you present it to the court, and then the court, whether a judge and or jury, decides. Isn't that the process? This whole thing with motion to dismiss is like, I don't know. I feel like it should go away almost, because it's just, I don't know, whatever. I'm sure like in some ways it's good, but it just feels like you're doubling the work and not really a fair system. Because like you don't have evidence at this point. I mean, we kind of have some evidence because of the way they chose to go about it, but usually people say like, no, you just kind of you are limited, and then you go to discovery. I think Friedman files, I think. Yeah, Friedman's alleged complaint, or alleged, oh my gosh, you know what I mean. And if not, that's okay. Yeah. um okay. The Wayfair parties have failed to allege any damages. Finally, and regardless of the theory, is it finally? Are we almost at the end? And regardless of the theory under which their claims are brought, the Wayfair parties have failed to sufficiently allege damages. Merely alluding to damages in a conclusory fashion does not suffice. The fact repeatedly asserts that the Wayfair parties were harmed and prays for a damage award of at least $400 million, but nowhere explains how or how much any of the Wayfair parties were actually damaged by any of the alleged conduct in the complaint. An allegation that a claimant suffered damages without particular facts as to how she was damaged does not satisfy Twombly and Iqbal. Those are cool names. Comfort in Oceanside versus Hertz Corporation. Well, I would say tell that to your wife, but I don't know. Oh, there's the Republican National Committee, or Commune, what is it? Versus Google. Interesting. That one is probably interesting. Um, an allegation that a claimant suffered damages without particular facts as to how she was damaged does not satisfy that. What is that even? Because they're quoting other things. Anyways, in the context of tortious interference with prospective economic advantage, I'm going to learn this tortious and tort and all this next time. I still don't remember what it is. Bye, Maria. Um, have fun working, and have fun at work. Have fun to get a what do you call it? I mean, she's gone now, but like have fun to like get relief, a break from all of this. Yeah. Sometimes I wonder for how many people work has become more enjoyable, because if we're like so invested in this, it's like it becomes kind of like a breath of fresh air. Like, oh, I don't have to like think about this for the next however many hours. Um, In the context of tortious interference with prospective economic advantage, California courts require specific facts to show that a benefit was almost certain. Sorry, thought I smelled something. The fact has nothing more than a bare assertion that the Wayfair parties were harmed and an unexplained demand for $400 million, but that is not enough to state a claim. Um, okay. The Wayfair complaint. I thought that was finally. The Wayfair complaint fails to allege conspiracy liability. Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the FAC attempts to hold him liable on a conspiracy theory. That attempt, sorry, fails. Under both California and New York law, a civil conspiracy theory requires that a plaintiff allege one, an agreement to participate in an unlawful act or a lawful act in an unlawful means. I mean, I feel like, no, okay. An overt, maybe not unlawful, I guess, immoral, I guess. An overt act performed in furtherance of the scheme. Nice pull. And an injury caused by the overt act. Conclusory allegations do not suffice. To survive a motion to dismiss, a complaint must contain more than general allegations in support of the conspiracy. Rather, it must allege the specific times, facts, and circumstances of the alleged conspiracy. I feel like I must really remember things wrongly or interpret things wrongly, because to me, when I read that, I'm like, but that's what they did. The first and the amended complaint, lawsuit, whatever, that Wayfair did have so many specific dates. I mean, literally, the amended complaint has the timeline with specific dates, time, meaning, and location to, the degree that it mattered, and all the other things, screenshots and all this stuff. They include so many facts. And then they also talk about the facts and then their interpretation of them, sure. But they include so many facts, whereas where are the facts included in the lively side? Nowhere. Like here's the list that we gave them, but we didn't give them this. They gave them 17 points or whatever, not 32. But here's the list that was done to me. And then believe me when I say that this is what I texted to this person that I'm not going to name, and I texted this. So I feel like, yes, back at you, ditto. I mean, I know this is like Ryan Reynolds focus, but sorry, that just kind of came up in my mind. Here, the fact pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement, and any damages. Even under the liberal pleading standards of Rule 8, a complaint must do more than assert that defendants agree to commit a tort. They still haven't provided proof. Yeah. Which, again, according to lawyers, I think that's like fine and dandy legally. But when you started with providing proof of the other people that you also kind of cut and pasted however you wanted, but you don't provide your own, that doesn't sit well to me. Stop filing and show facts with proof. Exactly. Where's the subpoena? Where are the text message screenshots? You gave us screenshots of the other parties. What about yours? And I think probably they would say, well, but we're, um, the defendants or whatever. We're not the defendants. We're the plaintiff. We're the one that, are saying this happened to us, whatever. So it's on them to say that it didn't. But I disagree if that's the argument. Um, more stuff, more stuff. Sorry, I'm just like, I also, oh gosh, I can't believe how fast. Oh my goodness. I won't get to the Blake Lively. Definitely not in this one, so I'll change my thumbnail. But there's not enough hours in the day. Not enough hours in the day. Also, just like a side note, I'm not going to break down like last time, but just like I appreciate you guys so much. I at the same time I'm holding both, just seeing that I only have like 3 of you, four, 5 of you. I know there's like a lot of more people that watch on replay. But I really want like replay people come on the live chats as well. I want to hear your thoughts, and yeah, it's just like I don't know, I'm holding both of those at the same time. I'm so glad that you guys are here, the ones that are though, for sure. Um I'm not glad that I'm not done with this. Oh, page 26. This is so long. Um, and also like again that ADHD, like I want to get to the new thing, Blake Lively's. But that is all the fact must can muster. Sorry. Oh, sorry. Did I read that? Yeah. Okay. Um. Okay, that's a whole bunch of stuff. Read Read individually or as a whole, the facts allegations that Mr. Reynolds participated in a conspiracy to engage in tortious conduct against any of the Wayfair plaintiffs are utterly conclusory. They amount to bare assertions. C. Asserting that Miss Lively, working with her husband, conspired to harm the Wayfair parties by advancing a narrative in the press, unsupported speculation. I mean, I don't know whether true or not. I imagine that's not true. I imagine that's true. I imagine that as a husband, that's what you would do, stand by your wife, but, or just someone you care about. You don't need to be married even. But, to a degree, I mean, I have my own thoughts, like I said, about Travis and Taylor back in 2021, I think. But anyways, so like I imagine that's true, but this is probably a good point legally. Like, how can you prove that? That's a harder one to prove. So far, what we've seen, like I think he had influence as far as like the industry, but in the media, I feel like it was her publicist more so that was more liable. But I don't know, or easily like proven to be more liable. Reciting elements of civil conspiracy liability. Okay. Appearing to recognize this deficiency, the Wayfair parties confine each of their allegations of conspiracy to information and belief. Um, but that only confirms that the Wayfair plaintiff's conspiracy allegations fall short because claims made solely on information and belief are insufficient to sustain a conspiracy theory. There is accordingly no basis to hold Mr. Reynolds liable for on a civil conspiracy theory for any of the conduct alleged in the fact. Are we done? How much more? Okay. All right. 3 more pages. 4 more pages? Oh, gosh, okay. The Wayfair complaint fails to allege conspiracy liability. Having failed to allege any plausible claim, sorry. Yes, live is interactive. Yeah, yeah. Yeah, I wonder why also, cuz I'm so bad at SEO and I'm so bad at like titles, all the things, but I do wonder like how do I make it at least like pop up in people's like feeds so they have the choice, to click on it and check it out. They don't have to like it, they can go away, but at least that, or I don't know, I would love to know how to do better. Cuz I know I'm still finding people, that I didn't find from the beginning. And yeah. Um it would be definitely also fun to like, yeah, hear more voices. Where was I? Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the fact, and also for you guys to interact, because that's like one thing that I love on other people's chats is that I don't even need to interact with the person on YouTube. Sometimes it's just fun to oh yeah, yeah. And sometimes not. That attempt fails under both California and New York law. Oh my gosh, that phrase. A civil conspiracy theory requires that a plaintiff allege an agreement to participate in an unlawful act, or, okay, we already read some of that. Conclusory allegations do not suffice. Here, the fact pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement. And as discussed, any damages, even under the liberal pleading. Oh, did I read this? I read this. I read that whole thing, or didn't I? Yeah, okay. It was 3 pages. When I went back, I kind of confused myself. Um, yeah, okay. Okay. All right. Yeah. All right. Sorry about that. Brief interruption in my brain. Mr. Reynolds is entitled to attorney's fees under the substantive fee shifting provision of New York's anti-SLAPP statute, not statute. New York Civil Rights Law 70A1, which applies to the facts allegations against Mr. Reynolds for similar reasons to those articulated in the Sloan and New York Times MTD motions to dismiss, both of which Mr. Reynolds joins and incorporate by reference. More stuff. Okay, holding that Section 70 applies in federal court because it creates a substantive cause of action for attorney's fees. It mandates a fee award in Mr. Reynolds' favor because, as discussed above, the fact asserts causes of action against him based on communication and conduct in furtherance of an issue of public interest, namely Mr. Baldoni's and Mr. Heath's harassing workplace conduct. And now we're bringing Mr. Heath again. I mean, this was is it a quote? No, it's not even a quote from them. Okay. And the subsequent retaliation and cannot survive a motion to dismiss for failure to state a claim. And then more stuff. Although this court reached a seemingly different conclusion in Brady versus New York something holdings, Mr. Reynolds respectfully submits that, so already there's a history of rejecting a motion to dismiss. Well, I mean, like probably a lot of motions to dismiss are rejected. Mr. Reynolds respectfully submits that the reasoning of Bobulinski. I'm sorry, that cannot be a real name. That's too good. That's too good. Bobulinski. Rather than Brady, should control here for 3 reasons. First, Bobulinski. Oh my god, I'm sorry. And I don't mean to laugh at someone's name. I don't know if that's someone or something, like a entity, like a company or whatever name. But yeah, it's priceless. First, in Brady, the defendant requested anti-SLAPP fees and a single foot. Oh, sorry, not they're just talking about the fees, not the motion to dismiss as a whole. So the defendant requested anti-SLAPP fees in a single footnote that did not analyze whether 70A applies in federal court, and the court accordingly did not have an opportunity to confront the arguments presented here or discussed in Bobulinski. I'm sure Americans pronounce that differently, but I don't know how to pronounce that in English. I just keep coming to Bobulinski. Motion to dismiss at 17 numbers, whatever, blah, 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 blah. Second, Brady was decided before the New York cases confirmed that 70A1 makes attorney's fees available not as a sanction, but wherever a SLAPP claim is dismissed for failure to state a claim. See Bobulinski. As interpreted by the New York courts, 70A1 is not a sanction but an exception to the American rule applicable to a class of cases defined by state law. For that reason, Brady's reasoning that Federal Rule 11 answers the question covered by 70A1 has been overtaken by intervening New York law. Third and finally, how many times? Finally, let this be finally for final. It is well settled, unsettled, that state fee shifting statutes are substantive laws that must apply in diversity cases. Just as the presence of Rule 11 would not be an obstacle to a prevailing party fee award where authorized by state or federal statute. Okay, this is, I mean, I didn't not much for me to understand. Arnaldo. Um, the court should strike Exhibit A to the Wayfarer complaint, or at a minimum disregard it. Okay. Mr. Reynolds joins the argument in the Sloan motion to dismiss, moving the court to strike the facts Exhibit A pursuant to Rule 12. As this court has recognized, permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint would do considerable damage to Rule 8's notice requirement, including by requiring a defendant to hunt around in voluminous materials to figure out what the plaintiff alleges. Tell that to your wife on this one. Is relevant and supports its claims, and what is extraneous. Even if the court does not strike Exhibit A, it cannot properly. Where are you calling? I don't know. You can't even see that. Okay. It's taking up my space though in here. Even if the court does not strike Exhibit A, it cannot properly consider it to evaluate whether the fact sufficiently states a claim. So, evidence is not like okay to submit, or like that's not evidence that will not prove a claim. That's my understanding as a non-law person. All claims against Mr. Reynolds should be dismissed with prejudice and without leave to amend, and the court should award Mr. Reynolds his cost, including attorney's fees incurred as a result of the consolidated action. Whatever. You're reading and I have dry throat. Yeah, I'm definitely my throat doesn't get that dry or whatever, but I'm definitely struggling with the lips. The lips are definitely dry. This is that's it for this one. So I'm going to change the title in the thumbnail to just be about Ryan's, and then I don't know. I should go eat lunch. I don't know if I have time before my class to start Blake's. I don't know. Maria, Blake's is probably longer. Yeah, it is. Well, no, it's not that much longer because I think based on what he was saying too, all the parties agreed for like around 30-page limit and only 15-page limit for what do you call it, response. Because they're probably like, we cannot do the 140 pages anymore. People like, we don't have time in the day to read all of this, like on both sides, on all sides. I'll pull that up right now. Although right now it seems like my internet is not really happening. But I had it pulled up somewhere. It is so strange that it's not loading. But all right. So maybe everyone's on court listener. Maybe it's just that one. So hers, I believe, is it this one? Which one is it? Gosh, so many not even availables. Wait, that's the one. No, that's not the one I read. Which one is this? Can I open it in a new link? As Counsel for Wayfarer Studios. Oh, this is okay. Yeah, I read that one last time. So I think it's this one. Yeah. And it starts here and it's 27 pages. So it's not too bad. Oh no, this is Judd Wallace. Oh, forgot about it. Didn't I just say that we forgot about him? I thought it was this one, but maybe I don't have it. No, sorry, there you go. Please let this be it. Yeah, so this is the consolidated defendant Blake Lively hereby moves to dismiss the amended complaint with prejudice. So all of the amended complaint and without leave to amend. pursuant to federal rule of whatever. And this should be the one. And it starts with that. Okay, so yeah. So it's 35 pages or so. Not too bad. Not too bad. It's precious. It's precious. I need, a break to like I'm just kind of stressed out by all the like life stuff that I have to yet do because I did wake up a little too late today. Excuse me. But yeah, I'll do this one. Um, if not before my class, I feel like I should do it after my class, not gonna lie, because I really want to get started with this. And if not, tomorrow during the day. Maybe tomorrow, I don't know. Just look out for my lives. Click that, bell notification, although I never get the notifications. Because I have them on, but then I have to be on YouTube and also I have to be like in the notifications part, but you'll see like the side, on, I don't know, depending on where you're going. I don't know. Anyways, I'm just like blabbing right now. Um, there's so many of us, doing this too. But if you can share, maybe other people can see it. I don't know. The YouTube is not a social media, so I don't know. But share these videos, and yeah, I have to just figure out the algorithm. One of the main reasons also that I went with at night and I went not too late was, well, mainly I went at that time because you guys were on at that time, um, and you chose that. But then also because a lot of the content creators are exactly in the middle of the day. And so I was like, I want to watch them first of all, and I don't want to like overwhelm with, like everyone's on at the same time, or compete, to be honest. And so like I feel like we all should have our own little specialty. Probably no one's early in the morning, but I'm not a morning person. So thank you, Maria. Yeah, I'm not a morning person, so that might be hard. But probably for my health, I should become a morning person to lose weight and to like just health reasons, like hormonal, balance or whatever, circadian rhythm, all that stuff. So maybe I'll become like a early morning person, and read through all of this. We'll see. But thank you guys for being here and for your support, and for putting up with my dry lips, and my weird pronunciations. What was that one? I want to like save that one. Oh shoot, I already closed it. I forget the name of it already. But anyways, I love that. That was such a cute name for. Where is it? Yeah, memorandum. I can't say anything. Bumbolonsky. Gosh, those are not as fun. Bobulinsky. There you go. Yeah, I need to save that one. That is so cool. I want to name. That's such a cute, like white dog name, and I think I say that because in Romania there was a play, and they had a dog, and they had, oh, it was a similar name for the dog. I just don't remember it now. I don't know. So that's why I'm like, ooh, small white dog name. But yeah, thank you so much. And I'll see you guys on the next one. And thank you for sharing and for being here and for your support. And I also will want to say, going forward, because this is so important, your mental health comes first. If any of this is too much, it's triggering anything from your past or just simply triggering, um, first acknowledge that and go towards it in a safe manner with a, mental health professional. And second, limit your exposure to this. And it's okay, we all will understand. I can't imagine any of the content creators that I've seen ever expecting anything less than that from you. So put your mental health first, your emotional health, your physical health, and we'll be here. I am starting already to talk about other things that I'm interested in. And I have some ideas actually on that too that I probably won't get to. Not probably, I will not get to this week. Maybe on Friday night, because Friday night it is more like let's chill. But yeah, Bobulinski, yeah. Um, yeah, I don't know. Maybe I'll introduce some things, but already talking about Megan and other things. So yeah, I don't know, but equally because I feel exhausted and I feel not necessarily triggered or triggering any PTSD or anything like that for me, but well, like I said, I couldn't read her complaint. That was very triggering to me as far as like manipulation and confusion, like creating confusion and manipulation, like kind of gaslighting situation. Um, because she wasn't really saying much. I mean, she was saying a lot, but not in a factual, simple way. It was more like calling upon emotion in a disturbing way to me. So I couldn't do that. But acknowledging that already, I was thinking like I want to do more to like balance it out for myself and for you guys, the viewers, because yeah, it drains you. Her anything that she said, like I literally cannot look at any of her interviews now. Just none. Because it's just like, oh, like, where am I? Where am I? What was even the question? She doesn't even know, and she admits it. And I'm like long winded. I say that, and I have my faults when it comes to that too. Um, anyways, but yeah, I want to like balance it out for our mental health. Like this should not be costing that. It should be entertainment. It should be like being aware of things. I think someone mentioned, was it on here or someone else? Um, that thank goodness that Steve Sarowitz is supporting Justin financially, um because, and I would say not just because of this particular case relating to him, his safety, his like career safety and personal safety, etc., but yeah, I think it was on Lauren's chat, was saying like this hopefully can stop them from becoming supernovas, because if no one challenges them, they become more and more bigger and bigger with power, and they can railroad over anyone at their whim if they want to, meaning. So this is where I'm coming from covering this, reading stuff that I am like, I'm over. I was over reading this, like, I don't know, 10 pages in or something. And I'm like, okay, I committed to reading all of this. And, showing up for this case as much as I do, even when I'm like, I don't feel like it. Like yesterday was so nice to take a break. I should have, come online and finish this. I didn't know that it was going to be crazier today. But yeah, it's, I don't know what I was saying. Anyways, whatever. Exactly. I'm glad that you got my point, Maria. And yeah, I agree. Variety is good for the soul. It is. It is. It is. We cannot sustain the same thing. We cannot eat the same thing over and over again, no matter if we think we do. Like, yeah. There was like a side note to that. Actually, there was a claim that I guess like, yeah, like you can eat the same stuff over and over or something. I don't know. On NPR, I think there was like a not documentary, but whatever, because it's radio. And there was this one woman that was saying that quite the opposite. Like you need to change up your food. We were developed to change up our food with the seasons, with what was available, etc. But also because to get nutrients that one food doesn't have but another food has. And so like, yeah, balance is what we're made for. So I don't know what that will look like, but it's coming. Anyways, have a wonderful day. And I'll see you guys the next time, wherever that will be. Peace, love, and compassion. And take care. Mental health, emotional health, physical health comes first, period. But thank you for your support, considering, that you're doing that first. Thank you for your support. Bye.